Hey guys, welcome back to the channel. This is the House of Law, and this is part two of my lecture on the law on partnership, agency, and trusts. And in this video, I will talk about agency and trusts. Now, if you missed the first video on partnership, you can watch the video up here, or also you can check the link to that video in the description box below. Now, if you're new to the channel, I'm Attorney Al, and I make videos on law subjects, and sometimes law-related issues. All right. Now, if you haven't subscribed yet, please subscribe. Please click that notification bell so that you will be notified in case I upload a new video. And also, if you find my videos helpful, go ahead and share the videos to your friends. All right. So, again, this is the law on agency and trusts. Let's begin. So, what is an agency and what are its elements? So, by a contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. And this definition is given us by Article 1868 of the Civil Code. Now, if you look at this definition, of course, you will find that it is a contract. So, there must be the presence of the three elements of a contract. You have the consent, the object, and the consideration. Now, we don't need to discuss those basic elements. Instead, let's discuss the distinguishing elements of a contract of agency. So, first is the parties' consent expressed or implied to establish the relationship. So, the principal must agree to hire or to engage this other person to be his agent, and this other person must agree to act as the agent of the other party, who will be the principal. Also, the object, which is the execution of a juridical act in relation to a third person. And because of this, we say that a contract of agency is a preparatory contract because the purpose of a contract of agency is to execute or to enter into a different contract with a third person. All right. So a contract of agency does not end with the establishment of the contract, but rather it is only the first step towards a different transaction or a different contract. All right. Okay. The third requisite or element is the representation by which the one who acts as agent does so not for himself, but as a representative of the principal. So if the agent is acting in his own name, then this is not a contract of agency. Rather, this is a contract by the agent with the principal. All right. Now, the fourth element is the presence of a limitation that the agent acts within the scope of his or her authority. Now, I know that you are familiar with general power of attorney and special power of attorney. And when we say general power of attorney, that's basically all acts, particularly acts of administration, but when we say special power of attorney, this refers to specific acts, particularly acts of ownership. But even if it's a general power of attorney, there must still be a limitation. And the limitation is that the power of attorney is only limited to acts of administration. So it's wrong to say that if the agent has been appointed without a special power of attorney, or meaning to say, without the specific powers provided to him, it means that the agent is free to do all acts. That's not true because the agent is still limited to acts of administration. All right. Okay, now, are the declarations of an alleged agent sufficient to establish an agency? If no, is there an exception, meaning an authority to represent another may be presumed? Well, in the case of Tuazon versus Ramos, GR number 156262, July 14, 2005, the Supreme Court said that the declarations of agents alone are generally insufficient to establish the fact or extent of their authority. The law makes no presumption of agency, proving its existence, nature, and extent is incumbent upon the person alleging it. Now, you may want to read this case. Now, if you haven't read this, this is a good case to explain or to show the difference between a contract of agency and a contract of sale. So here, the Tuazons were claiming that they were mere agents of Ramos and that they acquired the cavans of rice from Ramos in order to sell them to third persons. However, those declarations were not proven by any evidence that they were in fact agents of Ramos. As a matter of fact, in this case, they even uh, issued post-dated checks to Ramos, and these post-dated checks were in their account. So normally, if you will remember, in a contract of agency, the agent receives the goods from the principal not as a buyer but as a representative, and that the agent is not personally liable to pay the price. It should be a third person. But in this case, the Tuazons paid for the price by issuing post-dated checks. And when those post-dated checks were dishonored by the bank, they came up with a defense that they were mere agents and that they were not liable for the price. So here the Supreme Court said those declarations are not enough. The contract of agency must be proved. Okay, and he who claims that he is an agent must show proof that in fact there was a contract of agency. However, okay, before that, uh, we also have this concept of agency by estoppel. Now, this contract of agency by estoppel is different from the declarations of an agent because in a contract of agency by estoppel, the declarations are made by the principal. So when a principal um, informs a third person or the public that he is represented by another person and allows this other person to do acts for him, for his behalf, then those declarations, those admissions, and his conduct can be taken to prove that there was, in fact, a contract of agency. So the difference now is that when the declarations are made by the agent, those declarations cannot be relied upon. But when these declarations are made by the principal, then those declarations are sufficient to establish a contract of agency, and a third person may transact with the person which the principal has offered to that third person to deal with. All right. So take note of Tuason versus Ramos versus the concept of agency by estoppel. All right. Next question. May an agent perform or exercise acts or functions not expressly conferred? Meaning to say, is an agent limited only to what has been stated in the power of attorney? Well, in the case of Citibank versus Chua, the Supreme Court said that it is a fundamental principle in the law of agency that every delegation of authority, whether general or special, carries with it, unless the contrary be expressed, implied authority to do all of those acts naturally and ordinarily done in such cases, which are reasonably necessary and proper to be done in order to carry into effect the main authority conferred. So, meaning to say, even if the power of attorney does not expressly provide for certain acts, but if these acts are related to or incidental to those expressly conferred, they are deemed authorized. Now, if you have ever tried preparing a special power of attorney, you will find there that there's a catch-all phrase at the penultimate paragraph in the special power of attorney, whereby the agent is given full power and authority to do acts that are necessary and incidental for those powers expressly conferred in that power of attorney. Although that statement in the power of attorney is a mere redundancy because under the law, okay, as explained in the case of Citibank versus Chua, an agent can exercise those not expressly granted but are incidental and necessary, okay, to those expressly granted. All right, I hope that's clear. Now, when is agency implied, and what is the difference between implied agency and agency by estoppel? All right, so here we will discuss again agency by estoppel. So, an implied agency or an agency may be implied, okay, from the following. First, from the acts of the agent which carry out the agency, such as when an agent, after having been informed that the principal wanted him to be his agent, the agent started or commenced with the representation. So even if that agent did not say yes to the invitation, but if that agent commenced and began representing the principal, then an agency has been implied from the acts of the agent. Now, the second instance when an agency may be implied is from the silence or inaction of the agent according to the circumstances. But the law explains that this is applicable only between persons who are present. So the principal can, of course, observe the demeanor of the agent. So silence may mean yes, but this is because the principal can observe the demeanor of the agent. But if the proposal or the invitation to create the contract of agency was made through correspondence, the silence or the inaction of the agent cannot be assumed as agreement to the contract of agency. All right. Next is if the principal delivers his power of attorney to the agent and the latter receives it without any objection. Okay. So the rule is that when the agent receives a power of attorney, specifically providing him or telling him what he has to do as an agent. If he doesn't accept, then he must inform the principal that he's not okay with the appointment. But if he remains silent and with that receipt of the special power of attorney, and if he does not object, then he's deemed to have agreed. Okay, by the way, you might be confused. In the case of number two, there is no special power of attorney there, so it could just be um, a text message or a letter, okay, inviting the other party, okay, but not a special power of attorney, okay, or a general power of attorney, which is of course, a more formal invitation. Okay, now you might also ask, what if it's simply by call? Well, the civil jurisprudence has been settled that a contract or an agreement done through phone is similar to a face-to-face negotiation. So we also apply the rules on face-to-face negotiation to contracts created by phone call. All right. Now, number four, between two persons who are absent when the principal transmits his power of attorney to the agent who receives it again without any objection. Also, when the principal entrusts to the agent by letter or telegram a power of attorney with respect to the business in which the agent is habitually engaged as an agent, and he did not reply to to the letter or telegram, then an agency is also implied there because obviously this agent is engaged in that business. So let's say it's this principal wants to sell his property and the agent is a real estate broker or agent, and the principal sends to this agent his power of attorney together with some documents maybe or titles to the property, and if this agent accepts them, the power of attorney and the documents without any objection, since he is engaged in the business of selling real property, then if he accepts it without objection, he is deemed to have accepted the engagement. All right. Now, agency by estoppel. I've already mentioned this earlier in comparison to the rule in Tuazon versus Ramos that declarations by the agent are not sufficient to establish agency. But here, by a contract of estoppel, the declarations of the principal are enough to establish, or at least no, to give an impression that, in fact, an agency was created and a third person may rely upon those declarations. But, okay, for better appreciation, let's look at the ruling of the Supreme Court in Professional Services Incorporated versus Agana. Here, the Supreme Court said that the principal is bound by the acts of his agent with the apparent authority which he knowingly permits the agent to assume or which he holds the agent out to the public as possessing. The question in every case is whether the principal has, by his voluntary act, placed the agent in such a situation that a person of ordinary prudence, conversant with business usages and the nature of the particular business, is justified in presuming that such agent has authority to perform the particular act in question. That's quite a very comprehensive ruling. It says that the declarations of the principal are sufficient for third persons to rely that the person who has been given this apparent authority is the agent of the principal, but at the same time, it gives some sort of requirement or duty upon a third person, okay, to exercise some type of diligence, because accordingly, if the other person is conversant with business usages and the nature of the particular business, and if the circumstances justify or support that this other person is the agent of the other person, then he can safely rely on that declaration or other evidence, such that he may, of course, transact with a third person, with the agent. This third person may now transact with that agent. So that is agency by estoppel. All right. When an agent is extended a general power of attorney, does the power include acts of dominion? The answer is no, because we said that an agency or a general power of attorney is limited only to acts of administration. All right, so agency, couched in general terms, comprises only acts of administration, even if the principal should state that he withholds no power or that the agent may execute such acts as he may consider appropriate, or even though the agency should authorize a general and unlimited management. Okay, so that's what I've been saying earlier, that an agent, even if given a general power of attorney, is still subject to some limitation, and that limitation is that he can only do acts of administration. Okay. Now, what are acts of administration? Acts of administration, as opposed to acts of ownership, pertain solely to management or superintendents. They do not necessarily pivot on ownership. Okay, so that was the ruling in United BF Homeowners versus Barangay Chairman of BF Homes, GR number 140092, September 8, 2006. Now, you can imagine, let's say, a business. So, if the agent is only given a general power of attorney, so he is limited to management and superintendence of the business. He can uh, perhaps maintain the business, preserve the business. He can do the regular or the ordinary business, but not to make loans, not to sell capital assets and all that, because that would, of course, involve acts of dominion or acts of ownership. Okay, but we are not saying that an agent cannot sell or cannot borrow money, but that act or those acts will require another type of power of attorney, and that is a special power of attorney. So, what agency requires a special power of attorney? We have the list under Article 1878 of the Civil Code. So, first is to make such payments as are not usually considered as acts of administration. Example are payments for capital investments, payments, loan repayments. But when we say payments to uh, ordinary or regular suppliers, which suppliers have already been, dealing with the business in the ordinary course of the business, then those do not require a special power of attorney because they are payments in relation to acts of administration. Also, to effect novations, which put an end to obligations already in existence at the time the agency was constituted. Okay. Why? Because novation is an act that extinguishes the obligation of the debtor. So here, if the principal is the creditor, only the principal himself can effect novation. Now, if the decision to novate the obligation of a third party debtor has already been made, and the agent is only tasked to implement that, then the act of implementing the novation, such as, for example, by signing off the debt, like delivering the note, okay, or whatever, or the new contract, those being mechanical acts, they can be done by the agent even without a special power of attorney. For after all, the agent will just be implementing the decision of the principal to novate the obligation of the third party debtor. All right, now another act that requires a special power of attorney is to compromise, to submit questions to arbitration, to renounce the right to appeal from a judgment, to waive objections to the venue of an action, or to abandon a prescription already acquired. Now, they don't involve property, but they involve rights. and these rights could be property rights. Therefore, only the right holder, when say the holder of the right, okay, may compromise, may waive these. Okay, so that means only the principal can. So because of that, if the agent is to exercise this, then there must be a special power of attorney from the principal who has the right to compromise, to submit questions to arbitration, and the like. All right. Next is to waive any obligation gratuitously. Now, this is almost the same as novation because both waiver of an obligation gratuitously, meaning by remission or condonation of the debt, as well as novations, these are modes of extinguishing an obligation. So they are acts of ownership. So if the agent is to exercise these acts, he must have a special power of attorney from the principal. Now, next is to enter into any contract which the ownership of an immovable is transmitted or acquired either gratuitously or for a valuable consideration. Well, clearly, this involves property rights of the principal. So, if the agent is to alienate, to encumber, or to sell, okay, the property either gratuitously or for a valuable consideration, that agent must have a special power of attorney. Okay, next, to make gifts except customary ones for charity or those made to employees in the business by the agent. Okay, so customary gifts meaning gifts that are on the occasion of some holiday or community or cultural celebrations. So, for example, Christmas, New Year, what else? Foundation Day. Okay, when gifts are customary, then the agent may do that even without the special power of attorney. Well, provided that, of course, the gifts are moderate and they do not affect adversely the capital position of the business or the principal. But if these gifts are more than customary gifts, so for example, in the case of a business and the agent wants to give out bonuses, okay, now these bonuses are more than customary gifts, so the authority to give bonus must come from the principal through a special power of attorney. Now, next is to loan or borrow money unless the latter act be urgent and indispensable for the preservation of the things which are under administration. All right, so that's clear. No, and the only exception um, from the requirement that the agent must have a special power of attorney if he wants to loan is when those loans are necessary for the preservation of the things which are under his or her administration. For example, if it's needed for the business, if it's needed for, let's say, the preservation of the apartments that are rented out and are being managed by the agent. Okay. Now, also to lease any real property. Speaking of lease, to lease any real property to another person for more than 1 year. So, if it's a lease for less than 1 year, that means the agent can enter into that contract even without a special power of attorney, even with just a general power of attorney. For after all, the law considers a lease for less than 1 year simply an act of administration or one that is related to the business of the principal. All right. Next is to bind the principal to render some service without compensation. Of course, that is something that the principal uh, should should decide. So it's an act of ownership. And so, if the agent wants, or if a third person wants to ask the principal um, or wants to ask the agent if the principal would be willing, okay, to render some service gratuitously, the agent cannot agree to that unless, of course, he has a special power of attorney from the principal. For after all, it is the principal who is personally liable and who will render that service. Okay, next, to bind the principal in a contract of partnership. Okay, why? Because a contract of partnership is a personal contract. It's based on trust, it's based on confidence, okay, and also because the principal uh, commits, okay, or undertakes to be subsidiarily liable to the obligations of the partnership in case the partnership becomes insolvent. So clearly, that is an act of ownership. So it should have, I mean, if the agent wants to bind the principal to that partnership, the agent must have a special power of attorney. Okay. Next, to obligate the principal as a guarantor or surety. So same concept as when a principal is invited to join a partnership. So the agent cannot also agree to bind the principal as guarantee or surety because there's a personal obligation to answer for the debt of another. So thus the principal must expressly allow the agent that power. So through a special power of attorney. Also to create or convey real rights over immovable property. So we already mentioned that. To accept or repudiate an inheritance because again this is a personal right that the principal can enjoy, can also waive and repudiate. So the principal must be very clear about it. And so if the agent is asked to exercise that for the principal must first execute a special power of attorney to make that binding upon the principal, this acceptance or repudiation. Also to ratify or recognize obligations contracted before the agency. Okay, again, the agent would not be empowered to do that because he was not yet an agent no, when these obligations were entered into. So again, the principal should issue or execute a special power of attorney. And lastly, any other act of strict dominion. So clearly, this means that the list under Article 1878 is not exclusive. So any other act, any other power that suggests it is a personal right or it is an act of ownership on the part of the principal that requires a special power of attorney. But question, is a special power of attorney in required to be in writing? Is there a required form for a special power of attorney? Well, that question was answered in Gozon versus Mercado, citing Lim Pinlao versus Liano Tian, where the Supreme Court said that the requirement of a special power of attorney refers to the nature of the authorization and not to its form. If the special power is not written, then it must be duly established by evidence. So the special power of attorney is the specific or the special authority. Okay, whether an agent has been authorized to do a specific act, it does not refer to the paper. Although of course it's called the special power of attorney or an SPA, but what prevails is the authority. So even if it's called a special power of attorney, but if the authority in the document only relates to acts of administration, then that is not a special power of attorney. So if a special power of attorney is not in writing, then it should be um, proven by other evidence. For example, testimony, other documents whereby the principal has confirmed or has acknowledge that the agent is empowered to do specific acts of ownership. So that can be received as proof of the special power of attorney. But take note that in the case of an agency to sell real property, here we have a specific form required by law, and that is it should be in writing. Otherwise, the sale is void. All right. So that's the exception to the rule that a special power of attorney need not be in writing. Okay, now, when is there an agency by operation of law? Is there even a thing called agency by operation of law? We only know express agency and implied agency, but is there an agency by operation of law? Well, let's take this in the proper context. It's called agency by operation of law because there is some need, okay, to prolong or to temporarily create an agency, even though the agency does not materialize, even though the contract does not materialize due to lack of consent or agreement of the parties, or perhaps because the uh, contract that is the subject of the agency has already been terminated or accomplished, or in case one or both of the parties have died. All right. So let's look at these situations when an agency is created, albeit temporarily, as provided for by law. All right. So first is when a person declines the agency and no new agent has been appointed, the agent or the person who has been invited to be an agent shall, for the time being, take care of the thing that was delivered to him if that thing was the subject of agency. Okay, but of course, he is not allowed to represent the principal because no agency was created. He did not agree to being the representative of the principal. But what we are saying here, or what the law is saying, is that this person, okay, must exercise due diligence to avoid loss or damage to the principal until such time that the principal is able to take the property back, or to remedy the situation because this other person failed or refused to accept the agency. Next is immediately after the agent withdraws from the agency, the agent must still do acts necessary to protect the interests of the principal. I mean, we are not just referring to the duty of accounting and all that. Of course, those are deemed necessary, in order to wind up the relationship between the principal and an agent. But uh, as far as the things are involved, as far as communicating with third persons is involved, then the agent should still at least represent to a certain extent, just to wind up, as I've said, the affairs of the principal with respect to the third persons. All right. Okay. Next is in case of extinguishment of the agency without the knowledge of the agent. Okay, so one of the examples, or one of the grounds for the extinguishment of an agency is the death of the principal. So in case of the extinguishment of the agency without the knowledge of the agent, the agency shall continue until such time that the agent has acquired knowledge of the extinguishment as well as the reason for the extinguishment of the agency. Okay, so the principal or his heirs, in case the principal has died, is still bound to pay the agent's compensation if a compensation has been agreed upon. Also, the agent's contracts with third persons prior to his notice of the reason for the extinguishment of the agency should be honored by the principal or his heirs if the principal has already died. By the way, what are the other causes of extinguishment of an agency? Well, we have, let's say, the dissolution of the corporation or the company that created or constituted the agency. So let's say this agent was hired by an employment manpower agency, and that manpower agency was dissolved by the state. So, and then the agent who was recruiting in some other province did not know that the manpower agency has been dissolved. So all his transactions in that province should still be honored, okay, by the agency. Okay. Huwag niyo na i-complicate. Mamaya sabihin niyo, paano hahabulin ng mga employees or ng mga na-hire kung wala na yung ano, iba na yun, labor law na yun, ha? So, hindi natin pag-usapan yun. But at least you get the idea. Okay. When an agency has been terminated, but the agent was not aware, okay, of the ground of the extinguishment of the agency. All right. And lastly, in case of the death of the agent. So, namatay na si agent. So, paano yan? So, who will act as an agent by operation of law? Well, it would be the heirs of the agent, but not for the purpose of representing the principal to third persons, but rather to exercise due diligence to take care of the thing, subject or object of the agency. All right, and of course, to inform the principal of the death of the agent. All right. Next, so what are the rights and obligations of the agent? So let's first look at the rights of an agent. So first is the right to be compensated. Okay, if of course it is agreed upon that the agency is for a compensation. Also, the right to appoint a substitute. Now, this is a right, meaning to say there is no need for the parties to stipulate in the contract of agency that the agent is allowed to hire a sub agent. Okay, it's a right. Now, the only way to suppress that right is if the principal and the agent agree or stipulate in the contract that the agent is not allowed to hire a sub agent. All right, next is the right to be reimbursed the sums advanced by him for the execution of the agency. All right, now, of course, these sums advanced are not necessarily his compensation, of course. That compensation is different from those expenses needed for the execution of the agency. Like, for example, when the agent has to spend, okay, in meetings or in traveling from one place to the other, okay, so those expenses may be reimbursed. Unless, of course, there is a stipulation to the contrary, meaning that the agent will have to spend using his own money. But if there is no such contrary stipulation, then the agent is entitled to a reimbursement of his advances. Now, let's look at the obligations of the agent. So, first is to carry out the agency and finish the business. All right. So, if you're an agent, if you take on the job, you must at least have your minds set on finishing the job. Okay. Now, it's the same as when lawyers accept cases. No, the lawyer should always see the case to the end. No, it's not just for the purpose of just accepting the case and then in the middle of the trial quit as a lawyer. Okay, as a lawyer, you are still considered an agent. So this applies to the lawyer. Now, of course, there are grounds for a lawyer to withdraw his services or to resign as counsel for a party. Now, those grounds are, of course, provided by the Code of Professional Responsibility. But then, uh, underneath it all, the lawyer acting as an agent of his client must carry out the agency and finish the business. All right. Next, to act in accordance with the instructions of the principal. So this is related to the scope of authority or the limitation of the authority of the agent. So the agent must follow that. All right. Now, speaking of speaking of um, um, the authority granted by the principal, what is the effect if the agent exceeds his scope of authority or violates the instructions of the principal? Well, the rule under Article 1403 or the Statute of Frauds is that when, no, not Statute of Frauds, okay, on unenforceable contracts, okay, so 1403 number one, okay, the Statute of Frauds is 1403 number two of the Civil Code. So under 1403 number one of the Civil Code, if an act is done or performed by a person who is not authorized or who has exceeded his authority, then the act or contract is unenforceable against the principal party. So the contract is unenforceable against the principal. All right, next, his obligation is to advance the necessary funds if such is stipulated. Or, similarly stated, to spend, okay, for the expenses of carrying out the agency if such was stipulated by the parties. Okay, now more on obligations of the agent. So first, next is to render an account of his transactions and to deliver whatever he may have received by virtue of the agency. So accounting is one of the important obligations because this accounting now is made in in relation to or consistent with the nature of contract of agency, and that is it is based on trust. Okay, so it's a fiduciary relationship. So the agent must make an accounting, okay, either at the end of the contract or at the end of the transaction or when so demanded or required by the principal. Now, by the way, if okay the agent fails to make an accounting when so required, well, he can be sued, okay, under the contract. That is a breach of the obligation. And also, there is criminal liability. The agent can be charged with estafa because there is violation of the trust and that the agent refused to return when there is such an obligation to return. So here, what is to be returned is not only cash, but also things or even real property, okay, that were the subject of a contract of agency. Now, if there's nothing to be returned, then accounting would still be proper so that the principal would know why there is why he or she will not be expecting anything, okay, in return, okay, from the agent. All right, next is the agent is liable to pay damages to the principal for his non-performance and for engaging in conflict of interest, okay, and also to answer to the principal for his fraud and negligence. Okay, so see here you will see that there are three instances when an agent may be held liable for damages to the principal. So first is when there is a failure to perform the obligation as agent. Second is when the agent commits a conflict of interest. Example of conflict of interest is that contemplated under Article 1491 of the Civil Code, where an agent is not allowed to buy the property of the principal. So, if the agent buys the property of the principal, then that is a conflict of interest. The reason of the prohibit the relative incapacity under Article 1491 is to prevent conflict of interest between the owner as well as the other person who has a relationship to the owner of the property, including the agent who has a relationship with the principal, his principal, who is also the owner of the property. Okay, so if the agent violates that, Article 1491, that is conflict of interest, so he can be held liable for damages. If Article 1491 makes the contract void, this provision, Article 1889, makes the agent liable for damages. And the last is Article 1909, when the agent will be held liable for damages if he is guilty of fraud in the discharge of his functions. Now, if the agent commits fraud to a third person, well, he and the principal can be held solidarily liable. That is something else altogether. No? But they are solidarily liable to the third person. This Article 1909 contemplates of the agent being liable for damages to the principal. Okay, next. What are the rights of the principal? Okay, including the obligations of the principal. So the first right of the principal is the right of control over the agent. Now, this right of control of the principal over the agent must be distinguished from the right of control of an employer over his employee, because the right of control of a principal over his agent is only limited to the result of the contract, meaning to say, result of the act or the task given to the agent. The principal has no, if not very limited control over how the agent will perform or will achieve the result desired. Unlike in the case of an employer and employee, the employer has the control over the means as well as the result of the activities of the employee. So that is why in your labor law, you have this concept of independent contractor. So an independent contractor is not an employee of the employer, because the employer has no control over the means, okay, of as to how the independent contractor will achieve the result, but the employer only has control over the result. So the same is true with principal and agent. All right, next is to be paid damages. So a principal has the right to indemnity if there is conflict between the interests of the principal and those of the agent, and the agent should prefer his own. So remember my earlier discussion. And also if the agent is guilty of fraud or negligence. Again, remember my earlier discussion. Next is the right to an accounting by the agent of his transactions and to the delivery of whatever the agent may have received by virtue of the agency. So you will see the obligations of the principal are just counterparts of the rights. The rights of the principal are just counterparts of the obligations of the agent. Okay. Now, next are the obligations of the principal. Okay, and so as I've said earlier, if the obligations of the principal are just the counterpart of the rights of the agent, now here the obligations, no, sorry, the rights of the principal are counterpart of the obligations of the agent. So here, the obligations of the principal are counterpart of the rights of the agent. All right, so first is to pay the agent his compensation unless the contrary was agreed upon, meaning to say, unless the contract of agency is gratuitous. Next is to comply with the obligations which the agent may have contracted within the scope of his authority, or those which the agent has done outside the scope of his authority but which the principal has ratified, or when the principal allowed the agent to act as though he had full powers. All right, that's Article 1910 and 1911. Now, take note of 1910 and 1911, because these two provisions also provide you the exceptions to the rule that when an agent exceeds his authority, the principal is not bound, because the contract entered into by an agent without authority or if he exceeds his authority is unenforceable under Article 1403, number one. So the exceptions are number one, if the agent or if the acts of the agent outside of his authority or without authority were ratified by the principal, or when the principal, by agency, for following the principle of agency by estoppel or apparent authority, made a third person believe that this agent is authorized to act as such. Actually, there is another reason, and this is when, or there is another ground, and that is when, okay, the acts of the agent are more advantageous or beneficial to the principal. So the principal would be bound. Like, for example, um, if the agent was instructed to collect payment by check, okay, but the agent was able to collect in cash, okay, so the transaction, even though against the original instruction, would still, bind or would still be valid and enforceable against the principal because it was more beneficial to the principal. Definitely collecting debts or obligations in cash would be more beneficial than if the obligation would be collected by check. All right. Now, what is this doctrine of imputed knowledge? So, the doctrine of imputed knowledge means that notice to the agent is notice to the principal. So, the principal is bound by whatever the agent is told or is informed of by reason of the transaction with the third person. Or if that agent um, acted within his authority, acted within his limits. So, if the contract states certain warranties or certain conditions, so those warranties and conditions, if they were communicated to the agent, are deemed communicated as well to the principal, and the principal is bound, okay, to those conditions and warranties. Okay, so that's the doctrine of imputed knowledge. All right, now in addition, we have the following obligations: to advance to or reimburse the agent the sums necessary for the execution of the agency or the damages which the execution of the agency has caused the agent without fault or negligence on his part. Okay? Unless, as I've said earlier, if there is a contrary stipulation where the agent shall shoulder all the expenses in carrying out the agency. But if the agent is not bound to shoulder those expenses, then the principal has to reimburse the expenses of the agent. But take note that this obligation or the right, this obligation of the principal or the right of the agent, okay, to be reimbursed is not absolute, okay, because the principal may refuse to make reimbursement under the following situations. So the principal is not liable for the expenses incurred by the agent in the following cases. Number one, if the agent acted in contravention of the principal's instructions, unless the latter should wish to avail himself of the benefits derived from the contract. All right. So as I've said, if the acts or the contract is more beneficial to the principal, or if the principal has ratified these acts, then the principal is bound. Okay, but okay, if he doesn't, if he persists that those transactions are unauthorized and those expenses were not authorized, then the principal is not liable to reimburse the agent. Okay. Next, when the expenses were due to the fault of the agent, as when the agent had to remedy the situation because of his negligence or fault. Okay, so those remedial measures cannot be reimbursed by the principal. Next, when the agent incurred them with knowledge that an unfavorable result would ensue if the principal was not aware thereof. Okay, meaning to say, if this risky expenses or risky endeavor or project was not with the authority or consent of the principal, then the agent shall be solely liable because he should know that it was risky or that it would be expensive. Okay, and he cannot just take the risk without asking the consent of the principal. Now, next is when it was stipulated that the expenses would be borne by the agent, or that the latter would be allowed only a certain sum. I mean to say there's a maximum amount that can be reimbursed. All right. Now, if by virtue of the agency, the act of the agent is the act of the principal, what else is a consequence of the agent being the alter ego of the principal. Ayan na, naulit lang. The principal is chargeable and bound by the knowledge of or notice to his agent received while the agent was acting as such. And this is the doctrine of imputed knowledge. All right. Now, let's have a true or false question. True or false, agency is revocable as it is a personal contract of representation based on trust and confidence reposed by the principal on his agent. Is it irrevocable or revocable by nature? Well, the answer is that agency is revocable by nature because it's fiduciary in nature. So if the relationship no longer works, then it should be terminated. It can be terminated. As a matter of fact, an agent can also withdraw anytime if he feels that the relationship is no longer working. But okay, there are instances when the agency cannot be revoked by the principal. Okay, so first is if a bilateral contract depends upon it. Let's say it depends. This bilateral contract depends upon the existence of the agency. Okay, for example, if uh, let's say, well, there was this case, no, I think it's called Republic versus Legaspi. Okay, all right. So in that case, Legaspi appointed Gutierrez as an agent, and at the same time, while he was agent, he would get 40% of the shares in the hidden treasures in the property of Legaspi. Okay, so clearly, Legaspi's property was being explored for hidden treasures, but to help manage the property to oversee the treasure hunting activities, Legaspi appointed Gutierrez as agent, and that he would get 40% of the shares in the hidden treasures. Because if you remember the rule on hidden treasures in your law on property, the owner gets 50% share in the hidden treasures, the other 50% being for the finder. Okay, now of course, if the finder is a trespasser, then he gets nothing. Okay, so here, okay, uh, in that case, Legaspi later on wanted to terminate the agency with Gutierrez, but Gutierrez refused. Of course, the matter became a case, and ultimately, the Supreme Court, ruled that it was an irrevocable agency because that agency had a bilateral contract that depends upon it. The bilateral contract being the treasure hunting activities. All right. Now, the second situation where an agency is irrevocable is if the agency is a means of fulfilling an obligation already contracted. An example is under Act 3135, a deed of a real estate mortgage must have a special power of attorney executed by the mortgagor in favor of the mortgagee, allowing the mortgagee to sell the mortgage property in case the obligation has matured and remained unpaid. Thus, the mortgagee will now be or has now been authorized by the mortgagor to sell the property, well, first to extrajudicially foreclose the property and sell the property on public auction. Now, that agency or that special power of attorney attached to the what they call this, the deed of real estate mortgage, is irrevocable because it cannot be revoked until, of course, the real estate mortgage has been fulfilled or has been extinguished, because that real estate mortgage created under Act 3135 depends upon the due existence of that special power of attorney. All right, now the last situation where an agency is irrevocable is in the case of a partner who was appointed manager in the articles of partnership. Now, just recall your law on partnership. There are two ways by which a managing partner can be appointed. One is in the contract itself, meaning in the articles of partnership or in the partnership agreement, and the other is by election or by selection of the other partners. So it is irrevocable agency when that managing partner was appointed, okay, in the articles of partnership, but his removal was without just or legal cause. So it is only irrevocable for as long as there is no legal or just cause. So if there is a legal or just cause, then that agency is revocable. All right. Now, how is an agency extinguished? So these are the modes of extinguishment under Article 1919 of the Civil Code. memorize if you can, but if not, then at least have a idea. But I'd like you to focus on revocation and withdrawal because these are the two common modes of revocation. Now, uh, two modes of extinguishing an agency. Now, notice that while the law provides for irrevocable agencies, the law does not state that an agent may not withdraw in or under certain situations. But the rule is that, of course, the agent must first comply with his obligations, like obligation to make an accounting, obligation to pay damages to the principal, etc. Okay, but the right to withdraw is recognized. Same with the right to revoke the agency when so exercised by the principal. Now, speaking of withdrawal by the agent, recall that, as I've said earlier, an attorney or a lawyer is considered an agent. Now, if an attorney or lawyer wants to withdraw, okay, from the case, he also has to comply with certain requirements as provided by the Code of Professional Responsibility as well as the rules of court when that lawyer wants to withdraw or resign from the case. All right. The other modes of extinguishment are, of course, death or civil interdiction, insanity or insolvency of the principal or of the agent, also by the dissolution of the firm or corporation which entrusted or accepted the agency, also by the accomplishment of the object or purpose of the agency, and by the expiration of the period for which the agency was constituted. So any of these modes or any of these situations will terminate the contract of agency. And if the agency is terminated, then their rights and obligations also cease. The prohibitions under Article 1491 of the Civil Code on the agent buying the property of the principal also will not apply. So they're free to transact like strangers, all right, and not bound by the conflict of interest as we have discussed earlier. All right, now let's talk. Let's look at some exercises. All right, first, question number one. Is a lawyer client relationship a contract of agency or a contract of lease of services or both? Explain your answer. Okay, so I've been saying it's a contract of agency, but I did not say it's entirely or exclusively a contract of agency. It's also a contract of lease of services because a client hires the lawyer to render some service, and that is maybe to represent him and to win the case. Now, because of this mix or hybrid nature of a lawyer client relationship, that it is both an agency and a lease of services, a lawyer enjoys some kind of independence or discretion so that he is not purely and entirely emboldened to the sorry, not emboldened, but beholden, okay, to the client. All right. Now, next question is a lawyer who is engaged to handle a case and represent a client, okay, in trial or in the trial also authorized to appear for pre-trial. Explain your answer. Well, the answer is no, because the authority to appear for trial is presumed under Rule 138 of the Rules of Court. So when a lawyer appears in court and says, respectfully appearing for the plaintiff, that presumption of authority is only limited to the trial, to the conduct of the trial in general. But when it comes to pretrial, we have a specific rule for pretrial. And here, the rules on pretrial require that the representative of the client must be authorized in writing. Okay, so if it's the lawyer who will represent the client because the client cannot appear personally, then that lawyer should also be issued or given a special authority to appear for pretrial in writing. Okay. Now, of course, if the client is present, okay, and the attorney is also there, the attorney need not present an authority in writing just to handle the trial because his authority to appear for trial is already provided under Rule 138. It would only require a written authority if the attorney is appearing for an absent client. All right, next question. Decide whether a contract of agency can be executed to enter into in the following. So, marriage, can a contract of agency be entered between, let's say, a party to the contract of marriage and another person who will stand in for this spouse? Well, the answer is no, because marriage is a personal act. the family code requires that the parties to a contract of marriage must appear personally before the solemnizing officer and must take each other as husband and wife. So marriage by proxy is not yet allowed here in the Philippines. Now, how about a contract of sale? Yes, a contract of agency may be entered into because the right or the privilege to sell or to buy property is not personal, okay, to the parties to the contract. It's a contractual right, but take note that the agent who appears or signs for one or both part for one or the other party to the contract of sale must be authorized by a special power of attorney. All right, now how about public office? Definitely no. You cannot execute a contract of agency if you're a public officer and make that agent sit in your office to discharge your functions because public office is a personal privilege. It's not just a right, but it's a personal privilege and must be exercised. Now, it's also a personal duty which you owe to your uh, constituents, to your government, even to the appointing authority. All right, now last is last will and testament. Definitely not again because under the law on succession, the execution of a last will and testament is personal, individual, and unilateral. Now, the only instance when another person may assist in the execution of the contract is execution of the last will and testament is when the task is only to mechanically write the wishes or mechanically write what was being dictated by the testator, or when this third person will help, or yes, probably will first help the testator sign the document or the last will and testament, or to entirely sign the document or last will in the presence of the testator and upon his instruction. All right. Okay, so that's it for the law on agency. Now let's have a quick break before we begin with the law on trusts. Now let's continue with the law on trusts. So, of course, we start with definitions. What is a trust? So a trust is the legal relationship between one person having an equitable relationship in property and another person owning the legal title to such property. The equitable ownership of the former entitling him to the performance of certain duties and the exercise of certain powers by the latter. So from this definition alone, you can see that there are two owners of a property. So one has the equitable ownership while the other has the legal ownership. Now, don't get me wrong, no? Not all properties or not in all occasions do we have these two different persons having equitable and legal ownership over the property. The concept of trust is really an equitable setup or arrangement in order to what prevent unjust enrichment, to promote fairness and justice. And the concept is, of course, treated or applied only in those instances which call for the application of the law. So, unless there is a basis or a situation that calls for the application of the law on trust, we will still have to respect, okay, the owner of the property as the only owner of the property, having both legal and equitable ownership. But okay, in a situation where there is a trust over a property, then you have two different owners, one who has the equitable ownership and the other has the legal ownership. But as defined, it gives importance or preference to the equitable owner because the equitable owner has the right to demand performance of certain duties and the exercise of certain acts by the legal owner or the person who has legal ownership. All right. Now, how do you know if one is the equitable owner and the other is the legal owner? Well, it's easy to determine the legal owner because the legal owner is the owner who is registered either in the registry of deeds if this is a real property placed under the torrent system, or even movable properties if there is some receipt or some document evidencing the ownership of the property. So whoever is publicly recognized as the owner is presumed to be the legal owner. Now, the problem lies with who has the legal ownership. So that one has to be proven because it's not found in any document, in any title. So he who claims that he has the legal ownership of the property must establish that convincingly, not just by preponderance of evidence, but the evidence must be able to make that conclusion. All right. So, what are the characteristics of a trust relationship? So, first, it is a relationship. So, there must be two parties, at least two parties. And also, it is a relationship of fiduciary character, meaning it is based on trust and confidence. Also, it is a relationship with respect to property, not one involving merely personal duties. So, it follows the property itself, no, and not just simply uh, a duty or obligation on the part of one particular or specific person, okay, to do something in favor of another specific person. It's a right with respect to the property, and it in fact can follow the property. Also, it involves the existence of equitable duties imposed upon the holder of the title to the property to deal with it for the benefit of another, and it arises as a result of a manifestation of intention to create the relationship. All right. Now, who are the parties to a trust? So there are generally two parties with respect to the creation of the trust. So you have the trustor, or the person who establishes the trust. Next is the trustee, or the person in whom confidence is reposed as regards property for the benefit of another. And lastly, the beneficiary. And the beneficiary is the person for whose benefit the trust has been created. Now, it is possible that the trustor is the beneficiary, also, trustor and the beneficiary at the same time, but it's not possible that the trustee is the beneficiary at the same time, or the trustee is the trustor at the same time. Because as we have said, the trust is a relationship. So there must be two distinct parties to a contract. Now, if the trustor is also the trustee, or let's say the trustee subsequently becomes the beneficiary, or the person contemplated as beneficiary of the trust, then there is now a merger of the parties. Therefore, the trust relationship is extinguished. All right. Now, what are the types of trust? So there are two types of trust. You have the express trust and the implied trust. So the express trust is defined as one that comes into existence only by the manifestation of an intention to create it by the one having legal and equitable dominion over the property made subject to it. Okay, there must exist a competent trustor and trustee, and ascertainable trust rests, and say the property, and sufficiently certain beneficiaries. Okay, like when you create a trust agreement, the trustor entrusts a property to the trustee with instructions to manage the property, to preserve the property until a certain time for the benefit of another. Okay? Because if there is no clear intention to manage it or to preserve it for the benefit of another, or worse, if there is no other person for whose benefit the property will be managed or preserved, then it's not a trust. It could be a donation because it's being given to the trustee, and also it could be an onerous transaction. It could be a sale. So to make it a trust, those elements must be present. There must be a competent trustor and trustee, identifiable. There must be a res property, let's say the trust property, and there must be a beneficiary. Again, it could be the trustor himself. Basta hindi po pwedeng si trustee siya din yung beneficiary unless of course he acquires the property subsequently. Hence, there is a merger of interests or personality. Now, it is created by some writing or deed or will, or by words evidencing an intention to create a trust. Now, if it is a trust, an express trust on real property, then it should be in writing. okay, for it to be enforceable. Remember that, because the civil code provides that unexpressed trust over real property cannot be proved by parole evidence. In other words, it cannot be proved by extraneous evidence or evidence outside of the document evidencing the trust agreement. So it should be in writing, and everything that is stated or contained in that written document is deemed to embody, okay, all the terms and conditions of that trust. Now, if it is a personal property, a trust agreement, an express trust agreement over personal property can be verbal. It need not be in writing. All right. So please remember that. Okay. Now, the other type of trust is the implied trust. So an implied trust is one that comes into existence either through implication of an intention to create a trust as a matter of law, or through the imposition of the trust irrespective of and even contrary to any such intention. So an implied trust can be implied from the intention of the parties, okay, which can be manifested through their acts, okay, or it could be a trust created by law, irrespective of or even contrary to the intention of the parties for the purpose of preventing unjust enrichment and to prevent fraud or wrongdoing. All right, so that's implied trust. Now, because of these two characteristics or descriptions of implied trust, there are two types of implied trust: resulting trust and constructive trust. So, what are the different types of implied trust? You have the resulting trust, or one that arises where a person makes or causes to be made a disposition of property under circumstances which raise an inference that he does not intend that the person taking or holding the property should have the beneficial interest in the property. So, there is an intention to create the trust. So the person creating it, the trustor, is usually the source of the money, and the other party who succeeds in having the title registered in his name will be considered the trustee. Okay. All right. Now, a constructive trust, on the other hand, is one imposed where a person holding title to property is subject to an equitable duty to convey it to another on the ground that he would be unjustly enriched. Meaning to say, the person who has the title to the property would be unjustly enriched if he were permitted to retain it. The duty to convey the property arises because it was acquired through fraud, duress, undue influence, or mistake, or through breach of a fiduciary duty, or through the wrongful disposition of another's property. Now, here, there is no intention to create a trust. There was no agreement, whether expressed or implied, but the legal owner or the person who succeeded in having the title registered in his name, okay, acquired the property through any of those circumstances: fraud, duress, undue influence, or mistake, or through breach of some fiduciary duty. That's why later on we will look at those instances, okay, as enumerated under the Civil Code, and we will know, or we will identify, which ones are implied constructive trust and which ones are implied resulting trust. Always remembering that a constructive trust is one created in order to prevent unjust enrichment because the acquisition of the property was done through fraud, duress, undue influence, mistake, or breach of some fiduciary duty. All right? Remember that. Okay, now what are the implied trusts under the Civil Code? So here they are. Article 1448 of the Civil Code provides sale to and transfer to one person, but the price is paid for by another. So this is an implied resulting trust. Okay, if there was an intention, okay, on the part of the source of the money to ask the other person to consummate the sale and have the property titled in his name. All right. Now, if, however, it was not, or if, however, that was not the intention, like if the other person was supposed to be acting only as an agent, therefore, he had no right to have the property titled in his name. But then later on, that agent, the source of the money, discovered that the agent had the property titled in his name. So here, the titling or the acquisition of the property was through fraud, okay, and through a breach of a fiduciary duty. Because remember, an agency is based on trust. Okay, so that would now become an implied constructive trust. All right? So basta implied resulting trust, may intention. Like, kuya, nandito ako sa Saudi ngayon, pwede bang pakibili tong property? Ikaw na muna ang mag-asikaso, ipatitulo mo muna tong property na to sa pangalan mo. Papadala ko sa iyo lahat ng mga kailangan, papeles, pera, etc. Tapos later on, ilipat mo na lang sa akin ang property. Okay, now if that was not in a written agreement, then that would be an implied resulting trust. Okay? Now, if that property was supposed to be purchased, but the OFW sibling in abroad would still be the party to the contract and would still be the registered owner, but the sibling here in the Philippines, in violation of the trust given to him, had the property titled in his name, then that would be a breach of a fiduciary obligation. So, magiging implied constructive trust. All right? Okay, now Article 1449 of the Civil Code speaks of donation to a person but beneficial interest is not enjoyed by the donee or that the beneficial interest is vested in another. Okay? So here, this could both be implied resulting trust and implied constructive trust. It would be implied resulting trust if really the intention was just ipapangalan ko lang muna sa'yo. Okay, if kunyari i-donate ko pero I will still enjoy the beneficial ownership. I will remain in the property. I will live here. I will ask my family. I will let my family live here. So basically, yung donee, legal ownership lang, titulo lang nasa kanya. Okay, now that would be a resulting trust because that would be pursuant to the intention of the parties. But if the donation was made in violation of some positive law, for example, the prohibition against void donations under Article 739 of the Civil Code between, for example, tatlo kasi yung situations doon. For example, between persons who are guilty of adultery. So si lalaki na may asawa, nagbigay siya ng property sa kabit niya. But because that is a void donation, ang gagawin ni lalaki, he will donate the property through a deed of donation to someone who is qualified. Halimbawa, kapatid niya or kaibigan niya. So the property will now be in the name of a person who is qualified under the law on donations, pero the property is enjoyed by a person, o yung beneficial ownership was in or with a person who would have been disqualified to receive that donation. So that would be an implied constructive trust. All right. Now, bago ko makalimutan, why is it important to make the distinction? Because, well, it is important to make the distinction because interests or demands of law, public policy, and social justice, may or can be used, to return the property to the rightful owner in the case of a public implied constructive trust. But if it is an implied resulting trust, of course, it is purely private and it is the intention to recover the property, the intention of the trustor or the beneficiary to recover the property that will have to follow. Okay, so yeah, yun. I hope you get this, no? Okay, next. Article 1450 of the Civil Code speaks of purchase with borrowed funds, the legal title vested in the lender, or payer only to secure the payment of the debt. This is an implied resulting trust because this is pursuant to the intention of the parties to have the title issued in the name of the lender, or the creditor for purposes only of securing the full payment of the obligation. Okay. Next, Article 1451 of the Civil Code speaks of legal title to land is inherited by the heir but placed in the name of another. Okay, now we know that under the law on succession, the property of the decedent or the estate must go to the rightful heirs, whether they be compulsory heirs or forced heirs or the voluntary heirs. Now, if you want to know more about succession, of course, you can watch at least four. I have four videos on succession in my playlist in this channel. So check nyo lang yun, no? There are four videos and actually five, no? there are two review videos there para mas maintindihan nyo yung dynamics, no, with respect to property inherited. So those property belong to the heirs, whether they be the forced or compulsory heirs or the voluntary heirs. Now, assuming that an heir succeeded, okay, in having the property titled, okay, in his name or in the name of another person, thereby omitting other heirs, okay, that, okay, property is held in trust for those who have the right to that property. So anong klaseng implied trust to? Is this implied resulting trust or implied constructive trust? Definitely this is an implied constructive trust because this was done in fraud of the other heirs. Pero don't get me wrong, pwede pa rin namang resulting trust. Bakit? Halimbawa, they executed an extrajudicial settlement, they still wanted to be the co-owners of the property, but because they didn't want the difficulty of having to transfer the property later on when some of the co-owners die, so magkakaroon na naman ng extrajudicial settlement, all that, so they decided to have it transferred or registered to the youngest of the co-owners. When you say the youngest of the heirs, expecting that this heir will live a long life. Pero yung iba, co-owners pa din. So they have a common right or right of enjoyment to the property. So resulting trust because that was the intention of the parties. But if the intention or if the transfer of the property to one heir or to another person uh, under the initiative of this specific heir, then that would be in fraud of the other heirs. Then it's an implied constructive trust. All right, next is Article 1452, which speaks of legal title to land is taken or placed in the name of one co-owner. Oh, nabigyan ko na kayo na isa example, di ba? So, for purposes of yung example ko kayo na, for purposes of convenience, they said, ipangalan na natin sa iyo kasi alam naman natin ang hirap nun. Tapos kung co-owners pa tayo, pag nag-file tayo ng SALN, we will have to declare our individual or respective shares in the co-ownership. So ikaw na lang, sa iyo na lang property, pero we are still co-owners. So that would be an implied resulting trust. All right, now Article 1453 is a situation referring to conveyance to a person in reliance upon his promise, okay, to hold it for or to transfer it to another. Obviously, this is an implied resulting trust because there was a promise to return it. Okay? All right, now next, Article 1454, absolute conveyance to a person to secure the performance of a grantor's obligation to him. Oh, ano tingin nyo kaya ang pinaka-precise example nito? Kailangan ko pa ba mag-isip? Kailangan ko pa magbigay ng example? Well, the example is equitable mortgage, di ba? So under the equitable mortgage doctrine, the property was sold by the seller, okay? They executed a sale with right of repurchase. The purpose is not to transfer or to convey the ownership, but rather to make that property the security for the payment of a debt. But because maybe the buyer demanded that gusto ko malinis na, gusto ko malipat na sa akin in case hindi mo mabayaran. Total, kung kaya mong bayaran, then you just buy back the property. We're done. Pero what if hindi mo mabayaran? Eh di para wala ng foreclosure, and all that legal requirements. Then, ibenta mo na lang sa akin, papalabas natin na binenta mo na with right of repurchase. And that would be the right to pay back what you borrowed from me. That would be the period. The period for the right of repurchase would be the same period for you to pay back what you borrowed from me. All right. Now, a implied resulting trust, of course, will be created there, no? Because the intention was really to make that property or to deliver that property as security for the loan. All right? So, pwedeng. Okay, may ako na-discuss ko ano mga consequences no, nitong mga implied constructive trust, implied resulting trust, and even express trusts. All right, Article 1455 speaks of purchase of property by a trustee with use of trust funds and causing legal title to be placed in his name or in another. All right, so trust funds. Ano ang pumapasok sa isip nyo dito? Mutual funds. Okay, so for example, when you invest in a mutual fund, okay, marami kayong investors doon, and let's say it's a bank or a financial institution who is the fund manager. So all your investments will be placed in the name of the fund manager, and the fund manager is authorized to invest these funds to different investments. It could be placed in stocks. It could be placed in money markets. It could be placed in real property investments. So the owners of the aliquot, or the portion, okay, of the specific portion of the funds, will have a right only with respect to the funds, or the percentage of the funds that pertain to him. All right. Now, that would be an implied resulting trust. Now, Article 1456 speaks of acquisition of property through mistake or fraud. The person acquiring it becomes the trustee for the benefit of the true owner. So here there was fraud or mistake. So the legal owner, okay, or the one who has succeeded in registering the property in his name, becomes the trustee for the rightful owner. Okay, example dito is when a property was applied for by a person not qualified, okay, under that property, or under the law respecting or governing that property, whether it be PD 1529 or the Property Registration Decree, Republic Act 6657, or the Comprehensive Agrarian Reform Program. Okay, now if the person who applied for it is not qualified, but they made use of evidence pertaining to another who should be the person qualified, then an implied constructive trust is created. Okay, so the rightful person, or the person who should have applied for that property, for example, under PD 1529, the person who is in possession, under 6657, the rightful farm beneficiary, ayan, sila pwede nilang mabawi yung property from the person who succeeded in having the property registered in their names. All right, so speaking of bawi, ito ang purpose ng trust. The law on trust gives now a cause of action to the person who has a better right to the property to recover the property by action for reconveyance. Okay? Action re vindicatoria. Now, question: how many years should the action for a conveyance be filed? Okay. Now, if the cause of action is based on trust, then it should be filed within 10 years. Okay. From, if it's an express trust, okay, 10 years from the repudiation of the trust. If it's an implied resulting trust, also 10 years from the repudiation of the trust. But in the case of an implied constructive trust, it should be filed within 10 years from the registration of the property in the name of the person, okay? Means of the constructive trustee. Okay? Kung sino man yung nakapwesto doon, kung sino man nagpatitulo niyan, then siya ang defendant. Okay? Ang plaintiff is yung nagsasabi na siya ang may better right to the property. Remember, 10 years from the registration of the property in the case of an implied constructive trust, 10 years naman from the repudiation of the trust in the case of an express trust or an implied resulting trust. What is repudiation? Repudiation means to renounce, okay? To contradict, okay, the trust obligation. Remember, sabi natin, a trust relationship creates the obligation on the part of the trustee to keep, manage, and preserve the property and return it when so required, okay, to, or deliver it when so required, to the beneficiary or to the trustor, as the case may be. So, how do you repudiate that? You repudiate that. How does the trustee repudiate that? The trustee repudiates that by declaring na, no, I don't recognize that obligation. Pero paano? Hindi naman siguro niya sasabihin na ganun. It can be deduced from his actions. Like, for example, constructing his own house, fencing the property, depriving the beneficiary or the trustor from enjoying or entering the property, and also from registering the property in his name. All right? So, kasama pa rin doon yung pagre-register. That would be a repudiation of the trust. All right? Okay. Now, let's look at some exercises and let's apply what we have learned so far. Okay, so first question. Heidi Klum is a German national, and while on holiday in the Philippines, she decided to buy a beachfront property in Bohol. Realizing that she is prohibited by law, she engaged a Filipino, Marcelo Dominguez,
as her dummy. She gave Marcelo 50 million pesos for the purpose of buying a beachfront property in Bohol. Marcelo Dominguez purchased the property, but contrary to their agreement, he deprived Heidi Klum the use or possession of the property. Is there a trust relationship between Heidi Klum and Marcelo Dominguez? Explain. And second question, will an action against Marcelo Dominguez for recovery or reconveyance of the land for prosper? How about an action for reimbursement? All right. So, hiniwalay kong question. So, wag natin i-discuss yung second question do sa first. Pag sumasagot kayo sa bar exam, basahin nyo muna ang mga questions. Huwag nyo uubusin yung mga sagot nyo doon sa one sub-question, di ba? Okay, kasi hindi maganda na uulitin nyo ang sagot nyo doon sa second sub-question. Obviously, because you're not reading the question correctly or properly. All right, so letter A, is there a trust relationship? The answer is no, because a trust cannot be used, okay, to circumvent the law, to perpetuate fraud, okay, or to commit a wrongdoing. Now here, Heidi Klum is a foreigner, so she can't acquire public agricultural lands in the Philippines. Okay, so hindi po pwedeng magkaroon ng trust agreement between Heidi Klum and Marcelo Dominguez, whether expressed or implied, because that would allow a disqualified person, okay, from acquiring the property through the vehicle or medium of trust relationship. Kasi kahit na nakapangalan kay Marcelo yan, if the equitable ownership is with Heidi Klum, a foreigner, that would still be a violation of the Constitution against um, acquisition of lands by foreigners. All right, now letter B. Will an action against Marcelo Dominguez for reconveyance of the land prosper? Well, the answer is no. Okay, why? Because as I've said, there is no trust agreement in this case, and because they violated the law, because the trust or the arrangement is void, then they are left where they are. Okay? Why? Because if we allow Marcelo Dominguez, sorry, if we allow Heidi Klum to recover the land based on an implied resulting trust, then that would allow Heidi Klum to own property in the Philippines. Okay, so no right of recovery. But question, may Heidi, okay, um, obtain or recover what she gave Marcelo, which is the amount of 50 million pesos? Well, it depends. Okay, if she was in good faith, thinking that she could buy property and it did not violate any law through Marcelo Dominguez, then she can recover it. But it's a question of fact, no? Although we say that good faith is presumed, pero pagdating dito kasi medyo public policy nang involved. So, kailangan niya i-prove talaga that she was in good faith. But if she were in bad faith, then she cannot recover the amount, no? Because that would, of course, uh, you know, allowing her or giving her an excuse, no, after violating our law. All right. Okay. Now, next question is A, B, C, and D are brothers and legal heirs of their late mother X. The latter's estate was subdivided equally among them, and each of them possessed and registered his share. However, 15 years later, when D was about to sell his lot, he discovered that C's share was greater than his, and C's landholding had encroached on D's land. Claiming that an implied trust was created between D and C, D filed an action for reconveyance. In his answer, C raised the defense of prescription. So, question, what kind of trust, if any, was created between C and D? Second, what is the prescriptive period of this action? C, when will the period start to commence? And D, is it required in this case for C to repudiate the trust before prescription will set in, and why? O yan, isa-isa ang sagot, so dapat isa-isa ang tanong, so dapat isa-isa ang sagot. Okay, what kind of trust, if any, was created between C and D? Okay, obviously, as sabi dito, C's property encroached on the property of D. Okay, so it was through mistake. Okay, so C's landholding exceeded what was supposed to be his rightful share, kung ano lang yung dapat para sa kanya. Kasi nga supposedly equal silang apat, pero mas malaki apparently yung nakuha ni C by mistake. Okay? So, sinabi natin basta by mistake? It's an implied constructive trust. Okay, next question. What is the prescriptive period of this action? Prescriptive period lang tinatanong, so period lang ibigay nyo, okay? So, 10 years. Total 10 years naman yan lahat eh. So, implied, express, at saka, implied, resulting, implied, constructive, 10 years. So, just stop there. And letter C, when will the period start to commence? So, the period will start to commence from, okay, the registration of the property. Okay? Because this is an implied constructive trust. Okay, letter D. Is it required in this case for C to repudiate the trust before prescription will set in? Why? No, because the titling of the land is the repudiation itself. Now, hindi lang naitanong dito, pero pag tinanong kita ngayon, ano ba? May D recover the property based on implied constructive trust? Tingnan natin ulit ang problem. Okay, the title was or the property, the respective shares were registered, okay, in the names of A, B, C, and D 15 years before, okay, D discovered that his property was less than that of C. So we can assume that the title was issued to C, okay, 15 years ago. So ibig sabihin kung magfa-file man ng action si D ngayon, more than 10 years na. So clearly the action has already prescribed. All right. Okay, guys. So that's it. I hope naintindihan nyo ang law on trust, no? Maganda ang law on trust because it gives this cause of action, no, for people who are entitled to the property but because of some, alam mo yon, kakulangan siguro sa kaalaman, kakulangan ng legal counsel, ganyan. Some people took advantage of them, that's why they lost their properties. At iba na ang nakapwesto doon at iba na ang nakarehistro na may-ari ng property. So, pwedeng gamitin ang law on trust using any of those provisions or examples under the civil code which create an either implied resulting trust or implied constructive trust. But all in all, I hope you learned something from this part 2 of my lecture on partnership, agency, and trusts. Okay, so thank you very much for watching. If you enjoyed this video, please hit the like button. If you haven't subscribed yet, subscribe na please. And then click that notification bell so that you will be notified in case I upload a new video. And if you feel na, siguro dapat meron pang ibang makapanood ng videos para matulungan sa bar or sa mga exams nila, please share na rin this video. It's free after all. Alright, thank you very much for watching. I'll see you in my next video. Laging tatandaan, mag-ingat dahil mainit at saka lagi tatandaan, isip ay buksan, alamin ang batas. Bye guys!